Sophie, I already hit record, so don't worry about that.
Oh, okay, good. Thank you.
Yes.
Yes, you kind of need to do the poll.
So this,
Sorry, I'm working on it.
this only works in here, right?
I think that because the room is messed up right now, we would speak into our speakers, but keep yourself muted until you want to speak. Otherwise, we're going to have all kinds of audio.
If you mute your speakers here, it'll be better.
Yeah, mine.
Hopefully they can do something.
All right, so everyone mute your speakers.
Your computer speaker, right?
Mm-hmm.
I think there's one on stuff. Oh.
All right. I'm calling this special meeting of the Newington Board of Education to order. Today is November 16th. The time now is 6:10 p.m. As you are able, would you please rise to your feet for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. So once again, I want to apologize for the technical difficulties that we are having. We are going to do a roll call at this time. Is Ms. Craig available to do that?
It's going to be Sophie.
Sophie's
I
doing
will
it.
be doing the roll call, Dr. Fletcher.
Okay, let's do it.
Michael Branda,
Here.
Danielle Drost. Here. Dr. Bruce Fletcher,
Present?
Beth Mankey Wegner. Here. Richard LaVerriere,
Present.
Amy Parati. Here. Sam Sharma.
Here.
I did not hear a response.
He's
for
here.
Here,
Yep,
Here.
in person,
in person.
Jessica Weaver. Is Jessica here?
No, she's not.
And Anastasia Yap,
Here,
in person or virtual?
virtually.
Thank you.
All right, thank you very much. Moving on to item B is our public participation. If there's anyone from the public that wishes to participate at this time on matters concerning the Board of Education, you can call. We can't call. You'll have to be able to do it virtual. Our system is not working in-house here.
That should work.
That will work? Okay, so,
Tested and fixed. Now this is a new problem.
all right, so the phone number to call is 860-665-8659, or you can raise your hand here in the Google Meet, and I will call upon you. We do ask that you limit your comments to 3 minutes. All right, I don't see any calls, no hands raised. So at this time, we're going to move on to our new business. We have one item tonight for this special meeting, and that is an update from Attorney Jessica Ritter. She's going to provide an overview of the current legal issues. So I'm going to turn it over to you, Attorney Ritter.
Thank you. I appreciate that. Sorry for the feedback, and given that we're doing this remotely, normally I would stand, but since my presentation's here, is it okay for everyone if I stay seated? Okay. So I know we only have about 45 minutes because you have a hard stop at 7. So I'm happy to address any, pressing issues or concerns that you want to discuss. What I was asked to discuss tonight by Dr. Brummett, though I can switch gears, is an overview of board member conduct and board member legal role and responsibilities, with an emphasis on the Freedom of Information Act. Does that sound about right, Dr. Brummett? Okay. I've had the pleasure of meeting some of you. For those of you who I haven't met, I'm Jessica Ritter from Shipman and Goodwin. I've had the pleasure of working with Newington for the last couple of years, and previously I had the pleasure of working with Dr. Brummett in her Plainville capacity. So I think you can see the presentation, most of you. If you look at the agenda, this is what we will cover. And unfortunately, Dr. Brummett, I think you'll have to be my slide advancer. Is that correct? All right. So let's go to the first slide. So remote Board of Education meetings. Now, I know that this has been a hot topic in many places. As you may know, during the pandemic, we had to pivot very quickly. So boards of education, municipalities, all forms of public government had to navigate the thorny waters of the pandemic and say, okay, well, we still have to be able to conduct business. School districts are still functioning, though mostly online. We have to be able to meet, but obviously it was a safety and a health issue to meet. And so we found lots of boards of education moving to have remote meetings. There were some temporary guidelines issued by the Freedom of Information Commission in conjunction with the legislature. This last legislative session, the ability to meet remotely or meet in a hybrid fashion like you are doing has become permanent. And so the FOI guidelines have now been codified into statute. Some of the important takeaways from what has recently been codified is if you are holding a regular meeting and you're going to offer it in either a remote or a hybrid fashion, you have 48 hours to provide the link to the public, because they then have 24 hours to say to you, I would like to participate in the meeting in live time, but I don't have the necessary equipment to do so. And so you would have to set up an area for them to participate in live time. If it's a special meeting, you do not have that 48-hour requirement. It would be appropriate to put the link and notify the public that you are holding something either in remote or hybrid fashion, along with the agenda that you post. With the regular meetings, the obligation to post the actual agenda is still the 24-hour requirement. So that hasn't changed. One thing that is important, though, for us to understand is previously you would see bylaws where boards of education or municipal entities would not allow members to participate electronically or by telephone, particularly with an executive session, because obviously there's a concern about making sure that the only person who is on the video or listening on the telephone is in fact a Board of Education member or a town council member. This law says that we have to allow, so by law or not, a Board of Education member to participate by means of electronic equipment. But that doesn't mean that we can't have expectations of conduct for Board of Education members who are participating in an executive session. I do know that Dr. Fletcher did issue hybrid meeting guidelines to that effect, which I think are perfectly appropriate as we talk about executive session, because I do think it's important that we maintain the integrity of the executive session, maintain the confidentiality of the executive session, and it's important to know that there's no one else in that room, particularly if you're discussing something that's highly confidential or attorney-client communication, because you could inadvertently waive that privilege, even if you just, by happenstance have someone in your family walking in the background. And so we want to be very mindful of our obligations as one to a whole entity. Any questions on that? I'm happy to. Yeah, sure, Amy.
Is there like a age limit if there's a child or anything like that?
Oh, I don't know what's.
Right, you have to go both. right?
Oh, I'll go mute. I'll mute.
On your computer.
Yeah, not this one.
So you have to actually turn your.
We can't hear anything.
Sorry about that.
Yeah, I just looking for clarification if you have to be absolutely completely 100% alone, no other person, regardless of age, in the room.
So that would be my recommendation. I mean, I have young children myself, but even my 8-year-old, I mean, technically that would be an inadvertent waiver of the privilege. She may not understand what we're talking about, but you never know if we're talking about something that impacts the school district and your child is a member of the school district and then they go in and tell their teacher what they overheard on the meeting. That could certainly be problematic. And that would be attributed to you, the board member, that waiver.
I have a question.
Okay, and Anastasia Yop has her hand up.
Hi, Jessica. How are you? I'm Anastasia Yap. I haven't had the privilege of meeting you yet. How are you?
Can you hear?
So I have a question. Seems like the question was directed towards me. So last meeting, since we're bringing this up, my 5-year-old, who is not a member of the school district at all, happened to be in the back, and he is not able to understand in any way anything that was going on. And he was, since Amy brought it up, he was in the background in his car seat. He's 4. And I think that's why that question was brought up. So that was more directed towards me. And I want to make sure. So my 4-year-old was in the background. He has no ability to understand. He is not a member of Newington Public Schools at all. So I had no other way to attend the meeting. We've had a lot of situations going on, as you're aware of, since you're part of Shipman and Goodwin. And I felt like it was important that, I be there and make sure that I can attend. But like you said, my son doesn't attend your school district. He doesn't understand or have the capability of understanding. And I can see the facial expressions, but I wanted to make sure, because that was essentially directed towards me, that it wasn't an issue. Because I also read the Connecticut School Book of Law. I am reading the bylaws. And although it might not have been appropriate, it's not illegal for my 4-year-old. And I made sure I showed everyone that nobody else was available except for my 4-year-old, who actually, I have an IEP that shows he cannot understand. So can you clarify that for me? Because it's not illegal.
Can you hear me, Mrs. Yap?
Now I can. You're asking me.
Okay. So I think it's a slightly different question what you're asking. Obviously, the preference would be that you be alone as part of an executive session. But I do understand, I am also a working mother, so I can certainly relate that what we don't want to do is prevent your participation. So if you have a 4-year-old, which is different from my 8-year-old who might attend the schools, right? And who
My
might
son does not attend the
some
schools.
of that. I think I'd have to defer to the collective consensus of your board, because while it is not illegal, I'd have to defer to what they're comfortable with. But I do think a 4-year-old is different from the example that I gave of my 8-year-old, who might be better able to process the information. And I certainly wouldn't want you to be prevented from participating because you had your young child with you.
Yeah, I only have
but
one
I can't point to an age specific.
Yeah, I just
There's
wanted
nothing
to
in
make
the law
sure.
that talks about an age specific or an exception for a toddler or for a young child. So I think, again, that's going to have to be up to the collective consensus of the board as to what they're comfortable with.
But there is no law that states, I mean, I went to almost every single board meeting. There's no law specifically that states, I showed them there was nobody else around. I was alone except for a 4-year-old in a car seat. That's what Amy's referring to. So I want to make sure that we're clear that I didn't break any laws.
Well, it's hard to say laws, right? It's about what the executive session entails. In an ideal, perfect world, you would have no one in the room with you. Though I wouldn't want you to be prohibited from participating because you're a very young child. Now, if your child were 10, it might be a different story.
No,
But
I only
your
have one
child who you're saying is not able to process the information, does
Nope.
not attend the Newington Public Schools at
No,
this
he
time.
does not.
Again, I'd have to defer to the collective consensus, but I'm not as concerned about that as I would be an older child.
Thank you.
Let me just address that real quick.
Sure.
As the chair during the meeting, I was aware of that situation. I did not stop her from participating because I understood the circumstances.
That was true.
I think what we're talking about is in general, overall, we got to have some kind of guidelines. The ideal thing that would be that we would be in person for an executive session. If not, that you would be in a private setting. Driving an automobile, that's understandable if you have to, but if you don't have to, the best thing is to be in a home. You can't be out walking in nature when we're having an executive session. So those are just some of the issues. And, the legislature has created new laws. That's why we're here tonight, so that everybody has an understanding of that. So that the next time we have an executive session, everybody understands where they need to be. and we can make appropriate plans for that. So, I had no issue myself, and I just think going forward, we got to make sure that we don't have distractions. So I'm
Thank
going
you.
to turn it back to you.
Anything else that I can address on the remote meetings? No? Okay. Dr. Brummett, do you want to advance the slides? So do you want me, in the interest of time, do you want me to just jump ahead to freedom of information? Dr. Brummett, would you want to talk more specifically about FOI?
I want to go there next, and then if there's other questions. We can-
Sure, okay. So,
can you talk about executive session
Yeah.
in general? That's
yeah,
FYI.
so that's part of FOI. So can we might have to jump ahead a little bit though. There's a few slides you'll have to go through. So if you could keep going. And we can certainly email all of this to you too, so that you have the comprehensive presentation. Normally it's a presentation that takes quite some time.
Oh, there it is.
Okay, so the Freedom of Information Act. So you're all elected officials, which means you are all subject to the Freedom of Information Act. So that essentially means that whether you conduct board business on your Yahoo account, your Gmail account, or your Newington account, though hopefully you are only conducting board business through your Newington account, that is all subject to public disclosure if it relates to a matter under your purview or your jurisdiction. It's the same thing with your phone, right? So if Danielle and Amy are having a text communication about how they might vote on a turf field, a proposal of a turf field, even though it's on your private phone, even potentially your work phone, because it's board business and you are public officials, if someone were to request a very broad FOI, it could fall within the scope of that request if they said, I want to see all text messages between Amy and Danielle over the last year. Now, I've seen this more in the last year than I've seen in 15 years of practicing. The public wants their information, they want it immediately, and they want to, in a lot of places, get you in a gotcha moment. So it is so important and imperative that you be very mindful about what you put in writing, and that you wouldn't mind if Hartford Current saw it. We also want to make sure that we're not engaging in illegal meetings through our correspondences. So if there's a quorum of you going back and forth through text messages, through an email, that could be construed as an illegal meeting. Even if it's just Amy and Danielle going back and forth, that's not going to be an illegal meeting because it's not a quorum of the board. But if you're talking about something related to board business, it is going to be subject to disclosure. I can't tell you how many requests of this nature that we're getting when there is an issue that might be controversial or gained a lot of notoriety in a school district, and board members' emails are being requested for up to the past year, text messages, correspondences. So again, I'd be very mindful about what you put in writing, be very deliberate about it, and be conscientious that you'd be okay if that text message or that correspondence had to be disclosed. So we want to be very thoughtful about that. If you could go to the next slide, Dr. Brummett, thank you. Sure, yeah.
I just want to clarify, but like if I
Text, like Beth and I went to a singing thing at school. I treated her for her birthday, right? And we're just talking, even though we're both board members, like that, if someone says, I want the FOI between the two of us, like, I don't have to share that. We went out
Absolutely
for
not.
drinks or whatever.
No, and I would defend that to the nth degree. And I've had that. I've had to make that distinction to say, the kind of transient emails between, Danielle and Beth saying, are you going to this party this weekend? Or did your son make the basketball team? That has nothing to do with board business. That has nothing to do with issues that you would address in a meeting. And so I would definitely say those are not disclosable. What would typically happen if you got a FOIA request for all your emails, your correspondences, your text messages, is Dr. Brummett's going to get our firm involved. We're going to send you what's called a litigation hold. And we're going to say to all of our board members, preserve everything you have that is responsive to this request. Hopefully you're all using your Newington email. Then it's very easy for IT to say, okay, we're going to use search terms last year, correspondences between Danielle and Beth, and then turf field. And then everything that comes up, your IT is going to pull, and then normally you'll have us look through those to ensure that we're not disclosing something that one is exempt from disclosure, like an attorney-client privilege communication or the like, or to make sure that it's responsive and within the scope of the request. And so you will be put on notice if there is a request made like that. And it might be, Danielle, that you say, well, Jessica, can you just look at these correspondences between Beth and me just to ensure that it doesn't fall within the scope? And then I would look at those and say, absolutely not. We're going to put these aside and not disclose these. You certainly have the right to be individuals and to have friendships outside of the board. So great question, Danielle. Dr. Brun, do you mind? All right, keep going. I want to get to so here's the definition of a meeting. So this is what I'm talking about, right? So a meeting is not just a hearing or proceeding of a quorum, but it can also be a communication by or to a quorum, right? To discuss or act upon a matter over which the public agency has supervision, control, jurisdiction, or advisory power. So Danielle, that is the language that I would use to exclude the correspondences that you're talking about between you and Beth. But again, it's the communication, and then it goes on to say whether in person or by means of electronic equipment, which is why your phones would apply to. We could go to the next slide, Dr. Okay, so what does a meeting not include? So personnel search committee. So when you were looking for your new superintendent of schools, for those of you who might have been on the board then, did you appoint the entire board as the personnel search committee? So what that means is you can meet without being subject to the posting requirements and the meeting requirements in order to conduct those meetings. And only when you actually voted on your final candidate did you have to do that through a posted meeting and through open session. A chance meeting or a social meeting. So Danielle and Beth, if you meet up somewhere, that's fine. If all of you have kids on the basketball team, that's fine. But if a quorum of you are at that basketball game and you take advantage of the fact that you're there and you start talking about board business, that could potentially be construed as an illegal meeting. Collective bargaining. So for those of you who are involved in collective bargaining, obviously most of your employees are unionized. So by law, collective bargaining negotiations are not subject to FOIA meetings. They are by definition what's called a non-meeting. And so we can meet without posting for those meetings, and those are closed to the public. The caucus of a single political party. So if the Republican caucus wants to meet, that's absolutely fine. They don't have to post for that. The Democratic caucus, same thing. If you bring Dr. Brummett, though, into your caucus, you have waived the privilege. If you bring a town chairperson, the Democratic town chairperson, the Republican town chairperson, you have waived that privilege. It's not a true caucus. I also get the question of, well, what about documents that I share within the caucus? Are those subject to disclosure? They are. So you can't say, well, this was a document I shared in caucus, and so therefore I don't have to disclose it. You will likely have to disclose it minus some other narrow exemption. So just be mindful about that when you go into your caucuses. Next slide, Dr. Barnett. And we can keep going. So types of meetings, I'll go through this very quickly. You have your regular, your special, your emergency. Regular, special, posted 24 hours in advance, though your regular meeting you schedule with the town clerk basically a year in advance. Your emergency meetings, nothing will ever constitute an emergency meeting. The only time an emergency meeting has ever been upheld by the commission is something very tragic, like a Newtown. Otherwise, you can wait the 24 hours to hold a special meeting. We can keep going. I want to get to the executive session stuff. We talked about this. The one big difference between a regular and a special meeting is a special meeting, I cannot add any new business. So if I forget to put the item with respect to whether or not we want new uniforms and it's a special meeting, I'm out of luck. If it's a regular meeting, by 2/3 vote of those present and voting, I can add a new agenda item. Okay, Dr. Brummett. Okay, so here, let's get to executive session. So Beth, I know you had questions here. Okay, okay, if we do a quick scenario, Beth.
That's great.
Okay, all right, so here's the scenario. So Nutmeg Board was in a special budget meeting when it learns of dire economic news that meant significant staffing cuts were necessary. Knowing that the board would need to discuss and decide the elimination of specific positions and not wishing to needlessly distress or excite its employees, the chair added an executive session item to the agenda to discuss, quote, personnel matters. With a 5-3 vote, the board entered executive session. After an hour of discussion, the board members agreed without a vote to direct the superintendent to cut 10 staff positions. So if we go to the next slide. Oh, go back, I'm sorry. What do we think about this? One, I guess I'd ask the question, is this an appropriate executive session?
I question that.
Okay.
I don't think it's appropriate,
Okay, why?
because you have an executive session, doesn't that have to be posted at least 24 hours in advance as well?
So an executive session actually never needs to be posted on the agenda.
Okay.
So an executive session is a status of a meeting that you do need 2/3 vote of those present and voting at the meeting to go into. But what I typically like to do as a courtesy to the public, I would say discussion concerning the superintendent's contract, in parentheses, proposed for executive session. Because then you're putting your public on notice and maybe asking you to leave the room, but you also don't know if you're going to get the votes. So to say executive session to discuss the superintendent's contract insinuates that you've preordained the voting outcome, right? And so you could just say discussion concerning the superintendent's contract, and then in the meeting, you could call for an executive session for that reason, but it's always best to put the public on notice. But it's not fatal if you haven't put executive session. What do you think about just saying an executive session for, quote, personnel matters? What do you think about that?
So you're allowed to have an executive session for personnel matters because it's confidential, but I don't think cutting positions is I don't think that falls under that purview. Like a personnel matter might be Mr.
Disciplinary.
Discipline, Mr. Joe Bob, came to school drinking, and we needed to have a discussion as a board. That would be a personnel matter. I just don't think that this constitutes necessarily, but I agree with it. I don't think you should be freaking people out, but.
So Danielle, you're 100% right on the latter point in that this is not a true executive session. Because an executive session for a personnel matter is specifically the discussion concerning the appointment, the removal, the discipline of a board member or an agent of the board, meaning an employee. So talking about which positions, which is not specific to a person, is not a true personnel matter as that's defined under the law. So you're exactly right with that. What you could do in the situation if you said, we really need to talk about this issue, but we're very concerned about the 5 kindergarten paras who will know that this is them. Through an attorney-client privilege communication, you could have an executive session to talk about the legal pros and cons or what it would look like for these people from a legal standpoint under their contract or their benefits. If in fact you were to do this, if you really wanted to have that conversation, that would be appropriate. It's not a true personnel matter. You're absolutely right. But to just say personnel matter as an executive session is an illegal executive session. It specifically has to be the discussion concerning the performance, the evaluation, or the dismissal of an employee or a board member. And so people do that all the time, and it's not a legal executive session. It's the same thing with an attorney-client communication. You can't just say discussion concerning an attorney-client communication. The FOIA commission would say, you have to give me some sense as to what you're discussing in executive session.
Yeah, sorry, I was hitting my microphone there. There we go. I got all these buttons, 3 buttons. Hey, that's really good. I should get a shirt that says that. Okay, so a few quick questions. So one, I heard you say an executive session about removing a board member. I was under the impression that there was a state statute that said that board members could not be removed by the board. So if you can hop into that in a minute. 5-3 vote, I thought it had to be 2/3. It's weird that they don't have a
majority.
Okay, I thought it was 2/3, so that's good to know. And then the other thing was when you had talked about the special meeting, I understand now that the executive session doesn't have to be on the agenda, but if this scenario, special meeting, are you allowed to go into an executive session during that special meeting? Or does it have to be
So that
a
was the next thing I was going to say. So this is an illegal addition because you're trying to add a new item to a special meeting. So that's another part of the wrinkle, another part of the example. So you caught on that. So when I was saying discussion concerning, and I'm sorry, Michael, I should have been clearer. It's discussion concerning the performance dismissal of an employee, and then the board member is specific to conduct. You're right that you can't remove, but you could discuss the performance of a board member, but you're right, you cannot remove a board member.
quick.
You legally don't have the right to do that.
Right. Okay, and quick follow-up then. So my understanding is censure is what the body could do in response to behavior, whatever you want to call it. Does that can that take place in executive session, the discussion around censure, or does that have to all be in public?
Okay, so a few things. If you want legal advice on how to censure a board member, and you just want to talk in the hypothetical and not specific to a board member, you're going to do that through an attorney-client communication. And the subject matter would be discussion concerning an attorney-client communication related to board member conduct, proposed for executive session. And then I could talk to you about how you do that, the pros and cons of doing something like that, and just what your rights are. And it's a process that plays out under Robert's rules. If it is specific to a board member, the chair is going to call the board member and say, we want to have a discussion related to your conduct. We're going to do it. We're going to propose it for an executive session. Now, you don't have to name the member. You can say discussion concerning the misconduct of a board member. You don't have to say of Michael Branda. But just like the superintendent or anyone who you're discussing the performance of, they would have the right to have that held in open session if they chose. Now, this is the distinction with a board member versus, let's say, the superintendent. You say to Dr. Brummett, we're going to discuss your contract. And she says, okay, but I want that discussion held in open session. You have to do it because you're discussing her performance. She demands it in open session. She's never going to do that because no superintendent would do that. But she cannot then demand that she's in your executive session. The difference is with a board member is they can absolutely still be in that executive session where you're discussing their conduct. You cannot exclude them from that because they are still a member of the entity. So that's, it does make for a complicated discussion sometimes. Any other questions, Michael, on that?
No, I'm good.
Okay. But yeah, so Michael also picked up on the fact that this was being done through a special meeting. So if we could just go to the next slide, Dr. Brummett. So, Beth, so here's some other things for executive session. And then if you have any specific questions, I'm happy to. So it's 2/3 needed to enter executive session, and that's Robert's rules. Your motion has to be clear as to the reason. So here are the limited reasons. So the personnel matters we talked about, remember, discussion concerning performance, evaluation, conduct of an employee, pending claims and litigation. You actually have to have been served the claim or the litigation. So it's not enough to say this mom threatened to sue us over this, so now we're having an executive session. It actually has to be that you've received the CHRO complaint, the State Department of Ed complaint, the lawsuit. You actually have to have that bait stamped. Security devices and real estate. So if you wanted to buy a building and you want to talk about, the appraisals of the building, and you want that obviously to be confidential so that you're not negotiating against yourself when you look to buy something or to sell something, you're allowed to do that in executive session. If you want to discuss where you put security cameras, where you put other security measures in place, obviously that can be done in executive session because we don't want people to have access to those things for obvious reasons. Confidential documents. So have any of you done expulsion hearings here? Yeah. So that would be a time where it'd be appropriate, because it's a confidential student matter, to be in executive session to receive that confidential information. And then collective bargaining, that's mostly done through a non-meeting, but if you are receiving specific documents of strategy, it also would be an appropriate executive session. But typically you do that through a non-meeting. Beth, anything specific that I can answer about executive session?
This did it. I wrote down here confidential documents, but is the conversation during executive session confidential? And what happens when the confidential nature of the documents and the discussion is breached in a very public way?
Yeah, so obviously the executive session, whether it's a physical document or whether it's information that you're receiving, is privileged to the entity. So it is not okay for an individual to decide on their own that I'm going to waive or disclose that privilege when I'm part of an entity. What some boards of education have done, if not going through the censure process, though I just went through a censure process in a school district this summer, for the very thing that you're talking about, for disclosing information that had been received in an executive session. It also could be that you could, file, like a restraining order or file something with the court to say that you have violated our confidentiality rights. And then if you were not in compliance with that court order, potentially you could be held in contempt for that behavior. And then the judicial process would play itself out. But the thing that's really, I think, important is the liability that could come. So let's say you're discussing something about an employee that's highly confidential, and then someone discloses information, but takes it a step further and says something that's potentially defamatory or is slandering the individual. Well, that could be reckless and you could be sued for that, right? But you're going to be sued as an individual for that. So you as board members are indemnified by law. So if you act within the scope of your responsibilities, the board is going to indemnify you because they have to, right? Meaning if I am in an expulsion hearing and I follow the protocols and I follow our policies, but then a parent decides they don't like the decision we made and they sue us, you're going to be indemnified such that your attorney's fees, you're going to have an attorney provided for you because you acted within the scope of your responsibilities. If, however, you share information you learned of in an executive session, and then someone wants to sue you for defamation, the board could decide, we're not going to indemnify you for that because that was reckless, that was negligent, outside the scope of your responsibilities, and you're going to be on your own for attorney's fees. Censuring process is the same. So the censuring process that I went through this summer, and it was in relation to that, the individual in question had to pay for their own attorney's fees to represent and defend themselves through the censure process. And so that is something that a board can decide to do if they feel that the member was acting recklessly. But you will have very strong protection if you are acting within the scope of your responsibilities.
Thank you. I think that makes a lot of sense, but I just have to, I guess publicly or not public or at the table, just state or said I have grave concerns about this board holding executive sessions because information has not been kept executive. And it's quite a lot of information, potential documents, not really sure. So I just have really grave concerns going forward about the executive session process, about anything that we say here, about expressing myself, about being part of a decision-making process when our roles and the expectations and the policies are not being upheld.
Yeah, and I do think, did Attorney Mooney come and talk to you about that back in October? Yeah, I think there was some discussion on that too. Yeah. Yeah, I mean, I think you all have to be on notice that there's some very significant liability for you as an individual, but also for the district if we are sharing things that are meant to be confidential. So we should remind and admonish everyone, right, that we should be we have a fiduciary obligation to the board and to the district as a whole, and we should be very thoughtful and mindful of that. Yeah, Michael.
All right, Anastasia Yop has her hand up.
So this my questions for Jessica. To Beth's concern, so what do you do when that's done and you're put into a situation where people are asking you questions and you don't really know how to answer them because it's not something that you knew they had knowledge of. Like, what do? You're kind of like backed into a corner. I mean, I know there's some things that I've seen online and I'm like, oh, okay. And then, people message us and ask us and say, well, what is your opinion? How do you answer that? I mean, there's tons of things all over the internet. So how do you answer those questions?
I mean, I'm not an attorney, but I can answer that one.
Sure.
I don't have the privilege to share that. I cannot share that information right
But
now.
then they've seen things that you didn't even know they saw. So then you feel kind of like, we're elected officials, right? We get elected by the public. So in my opinion, that would make the public feel like we're hiding something from them, even though it's not our intention. But if they have privileged documents and information and you want to be reelected and you want, the public to think they can trust you, how does the public trust you when they have access to things you don't know that they have access to?
Your integrity to keep a confidence is more important than sharing information.
I understand that. But do you get what I'm saying? Like, if somebody goes, well, hey, how come you didn't tell me this? You didn't think this was important? And I say, it was confidential. I'm not sure how you received that, and I guess I just refer them to Dr. Brummett or you, right?
Yeah, I would definitely refer them to Dr. Brummett.
Sorry.
Thank you.
Go ahead.
I was just going to say that situation did happen to me, and I said I'm concerned about how that information was given out, and I said when deliberating matters, and I listed out the reasons for an executive session. I said these matters are executive, and I said I would direct your questions toward our chair, our superintendent, and they can guide you. But I kind of put it back, and I said to them, I'm concerned that you have information or that the public has information that was not supposed to be released. And these are the reasons why, I guess.
Thank you.
Another thing to keep in mind when you receive confidential information is through a collective bargaining process, but also by state law, you serve as judge and jury with respect to personnel matters. And so if you're receiving information through a privileged context, through an executive session specifically related to a personnel matter that then later you might have to sit judge and jury on, you have to maintain a level of impartiality. If you are discussing these things outside of executive session or outside of what is appropriate at all, because in most situations, you really aren't going to get information on pending personnel matters until there's a resolution or until it's before you in some type of, quasi-judicial hearing. And so it's really important because otherwise you could be stuck holding on to someone you don't want to hold on to that Dr. Brummett has said this person is not good for the school district, but they have due process protections and they can't get a fair hearing before the Board of Education because 3 of them went on the internet to say this person should be fired immediately and started saying things that either they learned in executive session or that they just assumed it happened and had no real knowledge. And that's a real concern. And if you're not stuck holding on to them, you could be tied up in litigation for years for defamation of character, etc. So you really also have to keep in mind what your role is as Board of Education members, particularly as it relates to personnel matters. So I had a situation where there was a serious DCF issue. The whole community knew about it. The teacher had been put on leave pending a DCF investigation. Dr. Brummett would not be at liberty to talk to you about that DCF investigation until there is resolution to it. Because 1, everything done with DCF with respect to students and staff is highly confidential, highly personal. But let's say DCF does not substantiate abuse or neglect. Then Dr. Brummett has to do her own investigation. Then she might decide to bring disciplinary action, which then would come to you as Board of Education members. If you had chapter and verse as to everything that happened before then, you're going in with a preconceived notion about how you're going to act on that. So you have to be very, very mindful. And people are going to come up to you in the grocery store and at soccer games and say, why is this teacher not fired yet? We heard this, we heard that. And you just have to say, I'm really sorry, but I cannot talk about that. It's a highly confidential personnel matter. And honestly, I don't know much about it because you shouldn't. And so these are things you have to be very aware of. And you're right, Bruce, you are just going to have to say, I'm just not at liberty to discuss that. And I understand that you have constituents and that you are elected officials. But again, I think you're right. I think the fiduciary obligation to the district outweighs whether you get that person's vote.
Yeah, really quick, because I know we're going to be up against it. So to Beth's point, I think, and it's happened over the years too, so it's not something specific to 2022, I don't think. But I think, executive sessions, I think that there has to be inherent trust between the entire body. And I think that that's where I'm struggling with a little bit in terms of just understanding, to Beth's point, what she says or what she expresses is not going to then leave this room if this is where executive session was taking place. So I think what I've come to kind of see is that it's a lot easier to be a bad actor in this situation than to, hold that bad actor contempt essentially for what they've done. Some people forward stuff to their personal email and then they, screenshot it or something. And, if I ask so-and-so, hey, I want to FOI your personal email, I'm going to wager my paycheck. I'm never going to hear back, or just, or I would have to go to court, and then we're talking about this huge ordeal. I just wonder, if there are trust issues, is it allowed ever that a Board of Ed recommends that a member of the Board of Ed or whatever body is not allowed to enter that executive session, or do they have to be a part of it?
Yeah, so you are not at liberty to prevent Board of Education members from attending executive session, right? You do have the ability to censure, you'd have the ability to seek a restraining order through the court process, which is done in very rare circumstances, but it has been done. You have the ability to censure, the board chair has the ability to strip committee assignments, but you can't prevent an elected official from participating in the democratic process. And that would include and encompass the executive session.
Okay, so given the time that we're at right now, is there anything else really important that somebody wants to bring up?
And Attorney Ritter, can I share this PowerPoint out with the full board? Because there are some other topics in here that were very helpful.
Of course, absolutely.
And she's going to have this slick clicker thing, but our technology got in the way. But
there's one. There's a virtual hand.
Oh,
Okay. Anastasia, let me
Yeah,
turn
this
my
is
speaker
very,
on.
very quick. I'm sorry. So
Go
one
ahead.
of the things that I think is a struggle is, so we follow like the charter, Robert's rules, our bylaws. And I think to Michael Branda's point, it's kind of a struggle because when you read one, it's, it says this, and then you read another thing and it says this. So essentially, if a board member is acting out of character and let's say somebody wants to speak to them, if they don't want to participate, is there nothing you can do? Or are they forced to participate?
To participate in a discussion.
Yeah, like say it's a discussion in regards to their behavior. If they don't want to participate, can you make them participate? Or
No, you can't make them participate.
so if the behavior continues to be erratic or whatever, you just have to deal with it until the next term. Is that what it is?
Well, you could censure them. I'm sorry, I don't know why it's echoing. Oh, sorry. Well, again, you can go through the censure process, which is pretty devastating. I mean, the few times that I've seen it happen, it's not an easy thing for an individual to experience. It's a public admonishment that certainly gains traction in the community, right? So it's not a great thing to your reputation, and it could potentially impact you moving forward from an election standpoint. But no, we can't force the board member to participate, but the board can proceed with or without that board member.
Got it. Thank you. Bruce, you're on mute.
so go ahead, Amy.
Thank you. I asked a question earlier. For my own benefit, I also have children ages 12 and 8 who are in the school system and do understand. So I appreciate your answers to my question, because that was solely for my own benefit, understanding if I can be in the kitchen on an executive meeting, if my children are running around. So I appreciate that. I will not be, because they can understand things that are happening, and I would not want to do anything to put the board at risk. Thank you.
Thank you. Any other board members want to make a comment? Okay. I'll entertain a motion to adjourn.
Second.
Motion's made and a second. Motion made and second. All in favor, say aye. We are adjourned. We got 5 minutes. We will re-adjourn.